Hello guys, so welcome to the Supreme Court judgment in this case of Iwuchukwu versus Nwizu. Now, the court held that with regards to the removal of the appellant as executive director, it is Exhibit 12 that states that his appointment in that capacity was terminated with effect from 16th of September 1983. It is this letter that provoked the institution of the action in this case. The question then is, was the appellant lawfully removed as executive director? The manner of removal may be specified in the articles of association concerned. In the absence of that, the manner of removal may be in accordance with the statutory provisions like Section 175 subsection 1 of the Companies Act 1968, which applies to a director appointed for a specific or a fixed time other than that for life, where the articles of association or the contract of employment as director does not specifically specify or fix the duration of the director's appointment. Such directors hold office at will and may be removed or dismissed by an ordinary resolution passed by the shareholders of the company at the general meeting. The Supreme Court quoted Company Law by Pennington 12th edition. There is something about this particular book, that's Company Law by Pennington, that he stated. Note that this is a UK authority and not a Nigerian authority. He said that the person holds office at will. The question is there anything like director at will under our KAMA 2020? I will tell you while we are discussing this case later on. Now we move on. He said by the provisions of Section 175 subsection 1 of the Companies Act 1968, every company has the power to remove any director before the expiration of his period of office, notwithstanding anything in the articles or in the director's contract of service. Meaning that subsection 1 of Section 175, which is equivalent to our own Section 288, says that you can remove a director at any time. Nothing in the articles can restrict you from doing so. Nothing in the memorandum or in the contract of employment can restrict you from doing so. You can always remove. That's what this provision is saying. And then the Supreme Court went further to say, however, the provision does not enable a private company to remove a director who held office for life. So that such director can only be removed if the articles of association says so. Note that that is under 1968 KAMA. Under 2020 KAMA, every director for life is removable. You have to go to Section 281. If you go to the provision of Section 281, it says that a director for life can be removed under Section 288. But under the previous KAMA, that is KAMA 1968, it says a director cannot be removed except the article of association so provides. That was what the removed director was basing his argument on, saying that since he did not have a period of office, therefore he can rightfully say that he was director for life. However, although the Supreme Court is seeming to say that he was director at will, the Court of Appeal was saying he was director at pleasure. Do you understand? And that was the basis of the argument of the company at the Supreme Court, that he was just a director at the pleasure of those who kept him there. That's the board. He was not a director at will. He was not a director for life. He wasn't a director for a fixed term. Now, the court here said the evidence adduced during the hearing of this case in the Federal High Court does not indicate that the appointment of the appellant as director was for a fixed term to suggest the application of the above provision of the Act. The court is saying Section 175 subsection 1 of the old KAMA, pari material with our own 288, does not apply to the removed director because there was no evidence that showed that he was appointed for a fixed term. Now, he said, okay, where it is not for a fixed term, then Section 175 does not apply. So how then do we remove him? We then have to resort to the articles of association. Furthermore, Exhibit 5 does not show that the appellant appointed as executive director was made for life, and no such evidence was adduced in the trial court. He said, therefore, the provision of subsection 1 is not applicable in this case. That's what the Supreme Court said. Similarly, all subsequent provision of the other subsection of 175 of the Companies Act, which deals with the procedure for or after the removal of a director by passing a resolution, except subsection 6 thereof, have no application to this present case. Now, we already know what subsection 6 says. it talked about derogating from any power to remove a director which may exist apart from this section. The import of this underlying provision in the subsection is that there may be a power to remove a director from office other than a resolution at the general meeting as envisaged by section 175. Usually the power is found where? In the articles. So therefore they perused through the articles of association. Article 13 is what talks about the removal of a director. He said the office of a director shall be vacated if, number one, if by notice in writing to the company he resigns such office. That is not applicable in this case because the removed director did not give notice to the company of his intention to resign. Then we go to B. If he becomes bankrupt or insolvent or enters into any agreement with his creditors generally. In this case, he did not become bankrupt or insolvent. C. If he is found lunatic or become of unsound mind. In this case, he was not mad and he wasn't of unsound mind. The court held that it is very clear that from the foregoing of Article A, Article B, and Article C, it does not apply to the appellant. No other procedure has been provided in Exhibit 1, which is the Article of Association, for the removal of a director of the second respondent. Therefore, the only procedure available to the second respondent where the appellant was removed from office on the 16th September 1983 as per Exhibit 12 is the procedure similar to that described by Section 175 subsection 1 of the Companies Act, that is, of calling a general meeting of shareholders to pass a resolution. So the court earlier said, okay, because you do not have a fixed term, we cannot say that section 175 subsection 1 applies to you. So if it does not, that means the whole of the provision except subsection 6 does not apply to you. Then they went to subsection 6. It says, okay, you can have it in your articles or in any other place. That's how to remove you, in the articles of the company or in any other place. They now went to the article. They went to Article 13. ABC does not apply to him. Then the court held that if Article ABC does not apply to you and there is no other provision that we can look for or we can find that applies to your case, we then have no choice but to resort back to that same section 175 as mentioned earlier in order to remove you as a director. So he said, as I mentioned earlier and as found by the trial judge, there was no proof of other resolution passed by the shareholders of the second respondent removing the appellant from office as executive director, notwithstanding the fact that Exhibit 17, which is a certified copy of the return of the particulars of director and changes amongst the director, which was sent by the second respondent to the registrar of companies on or about the 29th of September 1983 in accordance with the section 191 sub 4 of the Companies Act 1968, showing that the appellant was removed by the subscribers to the memorandum and articles of association with effect from 16th of September 1983 because the trial judge found it to be a sham. When they knew that what they did was not in line with the act, they now decided to comply with section 191 of the act that says that every time when you alter or you change your directors, make sure that you send the particulars of return as well as the new directors. The particulars of return is for those who are returning, and then the new directors that you are adding to the board, send it to the CAC. The court said the evidence where they did it and this person's name was not there is a sham because you did not do it in line with following the procedure of the law. You did it so that we can think that, oh, you have done the right thing. No, you have not removed him in accordance with the law. With respect, therefore, the Court of Appeal was in serious error when it held that the appointment of the appellant was lawfully terminated at will on his being offered 3 months salary in lieu of notice. It is his appointment as the special assistant to the managing director that requires and can be lawfully affected by such notice or payment in lieu of notice. Removal from the office of director in absence of a provision in the articles of association or contract demands a different approach, which involves the calling of a general meeting and the passing of an ordinary resolution removing the appellant. The respondent's case, as per paragraph 17, 18, and 19 of the statement of defense, was that a special meeting of the company was called. However, the evidence showed that no notice of such meeting was served on the appellant and no minutes of the meeting was produced at the hearing in the Federal High Court. Consequently, the learned trial judge was right in finding that no general meeting of the company was in fact held, and there was no ordinary resolution passed by the company removing the appellant as its executive director. It follows therefore that the proper procedure for removing the appellant from his appointment as executive director had not been followed. So according to the court, he was a director at will. Do you understand? Because he's a director at will and not a director for a fixed term, he was supposed to be removed in accordance with the provision of section 175 subsection 1, which is our own section 288 subsection 1. If he's not removed in accordance with that provision, where a general meeting is called and the resolution is passed, and another resolution is passed in line with section 258, if that does not happen, there is not properly removed, except there is an alternative way of removal which must have been provided through subsection 6 of section 288, which is section 175 of the old act. And then they went to the articles and then they found nothing, and then there was nothing before the court that showed an alternative removal. In the absence of an alternative removal, section 288 shall always apply to remove a director. Do you understand? And then lastly, the Supreme Court held that, I think, to point out that where a director is removed from a power in the Articles of Association, or in accordance with section 175 of the Companies Act, or indeed by an ordinary resolution, he may sue by virtue of the provision of section 175(6) of Companies Act, which is our own section 2886, for wrongful dismissal or compensation for loss of office, if he has, look at it, if he has an express service contract which does not empower the company to dismiss him in that way. Where you want to sue for compensation, because you cannot sue that they cannot remove you. The company can always at any time remove a director, notwithstanding what is stated in the articles, notwithstanding what is stated in the contract. The company can always remove its director. What you can do is make a separate contract as you are about to enter, called an express service contract, and that express service contract can create a provision there that says that the company may not remove you until your tenure expires. But we both know that that provision will not stand, because the company will always have the power to remove you. However, while you put it in your service contract that where there is a breach, this is the so amount I want to get as my compensation. So at the end of the day, you don't lose totally. But in my note, I'd already provided for everybody a summary of the case in such a way that you don't have to read the whole case. However, there is something that is very, very important, which Professor Bolo Dioku pointed out. Professor Bolo Dioku, who is the Dean of the Faculty of Law, quite frankly disagreed with the decision in Iwuchukwu versus Nwizu, because according to Iwuchukwu versus Nwizu, they said that he does not have period of office and he does not have fixed term of office. Do you understand? It was the absence of that fixed term that the Court of Appeal held that he was a director at pleasure, and therefore his appointment could be terminated at any point, relying on the provision of such termination from his contract as the special assistant to the managing director. But if you look at the provision of section 285 subsection 1, which states that unless the article provides otherwise, if the article provides otherwise, then it's fine. But if the article does not provide, at the first annual general meeting of a company, all directors shall retire, and in subsequent annual general meeting, 1/3 of the directors shall retire. It means that there is already a period of office for every director, unless the article stipulates otherwise. And how many years? 1 year. So if it already states that there is 1 year for every director, why then would the court say that there was no period of office? The only reasonable explanation to it is to say that perhaps under the 1968 CAMA, there was no equivalent of section 285 that talks about the period of office to be 1 year for every director. So by virtue of section 285 of all directors have a period of office. This contradicts the decision of the Supreme Court in Iwuchukwu's case that there was no period of office and the director held office at will. It should be noted that there is nothing as director at will under KAMA 2020. We have first appointed directors under section 272, we have subsequent appointed directors under section 273, and then we have casually appointed directors under section 274, and the other mode of appointment can be seen under section 46.3. The fourth provision that has to do with appointment of directors has nothing to do with director at will. If a contract does not stipulate a fixed term of years, such director is said to have a period of office by virtue of section 285. Note that if the contract does not stipulate a specific tenure and is removed, he can't claim damages for breach of contract as there was no contractual rights. So basically we are done with our lecture on how to remove a director. We already know how to remove a director now, that you have to follow the provisions of section 288 from 1 to 3. If you don't follow it, then it means that you must have had an alternative way to remove. Do you understand? And if you don't have an alternative way to remove, then you must follow it. Where it is not followed, then that director has not been removed in accordance with the law. Do you understand? So in my next class, I'll be talking about removal of managing director. I will see you in my next class.